Ma'am, can we start the session? Is
Absolutely.
you
I
allowed?
mean, unless you're waiting for more people, I'm happy to start whenever.
I guess it's already 7:30 and we have good number of people here and they can
Perfect.
keep joining in between.
Okay, excellent. And thank you so much for inviting me. It's a pleasure to do this. I have never been to NUJS, but I have written for one of your journals, Journal of Indian Law and Society. So it's a pleasure to be here and speak with all of you. The work I'm going to talk about today, this is a paper that got published in 2015. And it is work that I did when I was doing my doctoral dissertation, while writing my PhD at George Mason University. And what I was really studying was amendments to the Indian Constitution. As you know, the Indian Constitution's, famously been amended now, I believe, more than 103 times or something like that. At that time, it was just shy of 100. And I was trying to understand why a constitutional democracy has so many constitutional amendments and what is really going on, right? And I also grew up in India in the 90s, right? And the 90s was a period of the big mandal resurgence, right? And there were a number of constitutional amendments when I was growing up that had to do with the Mandal Commission report and Indira Sahani and the cases that followed. But I just wanted to understand what was going on, not just what I had lived through. And I figured that let's just start going through amendment by amendment. So that's really where this project started. I'm just going to present this a set of slides now because there's a fair bit of information. So that was the impetus for starting, and some of this actually becomes quite clear when you look at this particular cartoon. Are you all able to see this cartoon? So it's a government publications shop, and a gentleman goes up there and says, "May I have a copy of the Constitution?" And the shopkeeper says, "Sorry, we don't sell periodicals," right? So at one point, the Indian Constitution has been amended so many times, it's almost like a bit of a joke. And we all know, having read, the 101 on constitutionalism or rule of law, that law needs to be stable, right? Law must not have discretion. It must not keep changing. It must be general. It must be applicable to all. So that is kind of the point of view with which I started digging, right? And what I found was, you go back to the Constituent Assembly debates, and the idea is that the soul of democracy is, one man, one value, right? Unfortunately, we are only trying to do this through adult franchise. We've never really tried to do this in the true sense, which also requires that the economic structure of society change. So to B.R. Ambedkar, socialism and constitutionalism were deeply intertwined, right? This is right at the framing of the Constitution. And so you can see there are a number of features in the Constitution that try and enable some kinds of socialist values, though most of them were in the directive principles at the time of the framing. And at the same time, they want political equality, right? This is Dr. Ambedkar. Dr. Ambedkar is sort of the architect of the Bill of Rights in one sense. The fact that we got equal protection to all in a highly fractionalized society like India, in post-colonial India, was itself something exceptional. And the reason for that is that the framers also believed in strong liberal constitutional values, right? So this is their, this dualism of having both some kind of socialist agenda or practice written in through the constitutional structure, and at the same time having all your good constitutional values, right? You have fundamental rights, you have procedure, a separation of powers, you have judicial independence, you have federalism. All of these things are simultaneously written into the Constitution, right? And the prevailing view is pretty standard. You open anyone who has written from, the time Ambedkar wrote till recently. I think Subhash Kashyap is the most recent person I referred to. And every single one of them will say that socialism and constitutionalism is so interdependent that it's almost synonymous, right? And if socialism and constitutionalism don't work, it is because we botched it up, right? It is because of the lack of political will, right? Either the leaders were too weak and they couldn't get it done, or the leaders like Indira Gandhi were too small and they were hogging power, right? That's the reason socialism and constitutionalism didn't work together, right? Uh, if you start reading history, now I know it's very fashionable in present modern day India to demonize Nehru. But until recently, one used to only hear of this kind of critique of Indira Gandhi, right? So the idea was that Nehru was this great constitutionalist, he was part of the framing. He was one of the members in the Constituent Assembly. He was, of course, the first prime minister, led the provisional parliament, and so on and so forth. So, right at the birth of the republic, Nehru got it right. He was the great constitutionalist. And then by the time Indira Gandhi came along, and as we know, in the worst case with the excesses of the emergency, things really started going downhill. Now I started digging into all of this a little bit more, when I was doing my doctoral work. And what I found was something a little bit different, when you start going over 100 amendments, one after the other. I actually I looked at each and every amending act, and I said, what's going on here? And you look at, between 1950 and 1980, which is the peak of socialism, and you find, at least I found the following, right? You have the Planning Commission, which creates these 5-year plans. The 5-year plans have these, big, broad agendas, right? We're going to focus on agriculture. We're going to abolish zamindari and so on and so forth. Now, obviously, the Planning Commission's recommendations and reports don't translate into law, right? So for that, some action needs to be taken either by parliament or state legislatures. And then state legislatures and parliament actually pass statutes, right, that give effect to 5-year plans. In fact, Nehru famously used to coordinate with all the state chief ministers in his fortnightlies, right? These letters he used to write every 2 weeks to chief ministers, and he would nudge and persuade and sometimes, outright give directives to tell them in which direction their legislature or their government should take the development plan, right, or the economic plan. Now, a lot of this legislation got challenged in court. And those who've read constitutional law are aware of this. The entire history of amendments of the Indian Constitution comes up because something was challenged in court, and then the courts struck it down, and then Parliament had to respond, right? So laws are passed, the judiciary holds this legislation unconstitutional, and then Parliament says, hey, it was unconstitutional per the existing constitution. We're going to change the constitution, and we are going to now give this legislation validity, right? And this trend I saw happening over and over again. I said, what is going on here? So that's kind of what started off this project, right? And eventually I realized that we have two values, socialism and constitutionalism, which are completely at odds with each other, because the values or the principles that require socialist planning to be effective are also the same methods or values that are directly in contravention with the principles of constitutionalism. And I'll just explain that in a moment. So when I say socialism, I don't mean, whatever is the cool new thing these days, Scandinavian form of government or something like that. That's not socialism, right? I mean socialism, the good old way, the way probably, Ludwig von Mises or someone would have defined it. Socialism requires social ownership of the means of production. It requires abolition of private property, right? That's one of the tenets. Everybody must own everything. In other words, the government must own everything for the people. Everything is public ownership, and then the government will decide how these resources are allocated, right? Mises argued, however, that the private ownership of means of production is really important, right? Without the private ownership of means of production, you don't understand what exchange means, right? So when we trade with each other, when I go to the marketplace and I buy vegetables, right? We have these exchange values. I give 100 rupees in exchange for, potatoes, for instance, right? What does that really mean, that exchange of 100 rupees for potatoes? It reflects something about the scarcity, right, of the 100 rupees and the potatoes. I value the potatoes more than 100 rupees. The shopkeeper values 100 rupees more than the potatoes. But underlying in that exchange is how much do potatoes cost relative to pretty much everything else? How scarce are potatoes? And you know this living in India, right? The moment there is any kind of a disruption in crops, you suddenly see prices go up. Most famously, prices of onions, right? Onions is one of those essential goods where the second there is a bad crop or there is a breakdown in transportation or something like that, the price of onions will just shoot up, right? And what does that mean? It means suddenly onions are more scarce than they were last week when we could buy them at half the price, right? Now, the only way this relationship or this exchange will produce anything, any meaningful information in the marketplace is through private ownership of property, right? If nothing belongs to anyone and no one is incentivized to actually use these means of production to their best interest, none of these values would emerge. Now, the problem is in a socialist system, when you have clamped down on private property and when you have clamped down on market prices, whatever emerges from this exchange, when people go to the ration shop and buy bananas or buy sugar, that does not reflect the scarcity value of the goods, which means you can't calculate profit and loss and rationally allocate these goods. How do we know what goes where? Right? Mises gave a great example when he was discussing this. And he said, how do socialist planners know whether railroads must be made of steel or platinum, right? We all instinctively know that they must be made of steel, not platinum. How do we know that? We know that, if we made railroads with platinum, it would be so prohibitively costly that, you could barely run a train within the NUJS campus, right? We instinctively know this. But why do we know this? We know this because we know the exchange values that have emerged from the market tell us that platinum is so scarce and so valuable and must be used only for those types of production processes where one cannot do without platinum, right? It's not easily substitutable. We also understand that steel and alloy, of course, is also, it's not that there is unlimited amount of steel, but compared to platinum can be much more cheaply produced, right? So that's the underlying intuition behind Mises' critique of socialist calculation. So what Mises said was, if you clamp down on means of production and you clamp down on prices, right, through means of price and quantity controls, what you get is a complete misallocation. You cannot rationally allocate goods in a society across the board, right? This is what was dubbed the impossibility of socialist calculation. It's not that, the planners weren't working hard enough. It's that it simply cannot be done, right? Now, to this comes the Hayekian critique. Now, Hayek said that given the impossibility of economic calculation, right? Given the impossibility of knowing ex ante if planners should use steel or they should use platinum for a particular production process, what you need to do to make socialism work is you need to give them an unlimited amount of discretion. Right? So the only way they can make this work is if they can say suddenly requisition all the platinum, maybe for a space program or something like that, for requisition it from all other aspects or all other uses in society, make sure it goes to the use that they think it must go to, because left to itself, that is not the socialist system cannot rationally allocate these goods, right? So what Hayek said was, given the impossibility of economic calculation, right? It's an if-then argument. So given that is impossible to do, the institutional structure that requires socialist planning to exist and to achieve its ends requires an unlimited amount of discretion, right? Now, this is where the problem is. So because of the impossibility of rational economic calculation, planners require unlimited discretion, right? From your 101 of constitutionalism, or if you open the first few pages of Dicey or Hayek, or whoever is studying rule of law, they would tell you that administrators need to be bound by general rules equally applicable to all without any discretion or arbitrariness. So you already see that socialist planning, the kind of discretion it requires, is now going to start running into trouble with constitutionalism. Second, planning necessarily discriminates. And, this is a fairly intuitive point, right? It's really important. The entire reason that socialist planning is implemented is that the planners believe that the market allocation is not fair or just, right? It's inequitable, which means that we need to start grouping people and treat groups differently in order to bring equity, right? Whatever equity means in the planner's vision or the planner's mind. And once again, constitutionalism requires equal treatment before the law, right? This is in a political sense, political equal. Planning requires that the state controls the means of production, right? The constitutionalism requires right to private property because it's fundamental to all other rights. I'll give you an example of right to private property being fundamental to all other rights, right? Now, imagine a world where there is no private property, where the government owns everything or can acquire anything willy-nilly, right? A very easy way to clamp down on religious freedom is just acquisition of the gurdwara, or the temple or the mosque or whatever it may be, right? No right to private property. Similarly, a real threat to freedom of speech would be to just, again, acquire the printing press, right? If you don't have the right to ownership of private property, then suddenly the government can clamp down on a whole number of other freedoms, not just something to do with economic freedom or running a business or something like that. In fact, when you look at the later, around emergency and even post-emergency cases, Mrs. Gandhi famously imposed huge restrictions on import of newsprint. That's the paper on which newspapers are printed. And because there were such high, restrictions, they had to be allocated between different newspapers. And the way she did it was that the largest newspapers got proportionally less paper, less newsprint, which meant that they would lose a lot of ad revenue. Now, this is a socialist act, right? It has to do with trade and tariffs and custom duties. But it has a direct impact on freedom of speech, because now suddenly newspaper owners are not in a position to sell their paper and make money. Right? So the right to private property is really fundamental, not just over controls and means of production, but the means of productions are the only way we can protect all our other freedoms. And finally, planning requires a high degree of agreement or centralization on a particular plan, right? This is our goal. We're going to abolish zamindari, or we're going to have land ceiling, or we're going to have, MRTP, which is control of monopoly practices, and so on and so forth. Whereas constitutionalism requires decentralized decision-making, right? We have checks and balances on this kind of centralization. Democracy in itself, through the operation of parliament, it's bicameral, and you know all those checks and balances. There's separation of powers between the executive, the legislature, and the judiciary. And there's also a vertical check on powers through federalism, right? Now, all this is a lot of background, because I want to set up this idea of what I mean by the incompatibility between socialism and constitutionalism. These words are really important. We tend to use them both colloquially and technically, right? And this table kind of lays out what I mean by socialist planning, and also, some of the technical aspects that are required for constitutionalism and rule of law to exist, right? So in the rest of this talk, I want to go over how this played out in India, right? Why am I saying that socialism and constitutionalism were incompatible? We know Hayek said it, right? We know that he was a scholar of both economics and rule of law, and he talked about this in The Road to Serfdom. There are a number of other scholars who've talked about some of these tensions, but how did it exactly play out in the Indian system? So, at the birth of the Republic, one of the biggest things that was going on was abolishing the zamindari system, right? And for those of you who have had your, your sequences in constitutional law, that some of the early cases in the zamindari question were the different states that passed different state statutes trying to implement land reform, right? The statute that got into a lot of trouble in this particular instance in 1950 and a little bit preceding 1950 was the statute from Bihar, right? So the issue was that the Bihar statute, actually, now in hindsight, it's quite clear that they were targeting this towards a few specific peoples, few zamindars who own just so much of the land in Bihar that without targeting them in some way, this land reform would have totally fallen flat. But what the Bihar statute did was it said that, land must be taken from these zamindars, these feudal estates must be broken up and it must be redistributed. But now comes the question of compensation, right? Because Article 31, which is part of the fundamental rights, and at that time it hadn't been deleted, it had just been, adopted actually. It required that, the state was of course allowed to acquire property, but it had to be done in public interest and it could not be done without giving compensation, right? That's the phrasing of Article 31. Now, the public interest part wasn't a problem because there was a huge discussion in the Constituent Assembly debates on whether zamindari abolition would qualify as public interest, right? And it did. So the problem with the Bihar law was not that it ran into trouble with Article 31 or the right to private property. The problem with the Bihar law was that it ran into trouble with equal protection, Article 14. And the reason was as follows. Because there were small landowners and there were some zamindars who just owned so much land that, it would be impossible to give them compensation. Or if they gave them compensation, it would defeat the purpose of land reform, right? So someone like Sir Kameshwar Singh, who owns like pretty much, a huge proportion of the state, if you gave them compensation, you're not really, making things more equitable, right? And in the process, you're also bankrupting the treasury. So how do we get around this problem? We say that rich zamindars will receive 1/20th the compensation as poor zamindars. That's what the statute said. Now that sounds perfectly reasonable because if the goal is to end zamindari as it was in the very first 5-year plan, then this is the way to proceed, right? But it also runs afoul with the constitution. So what happened was, there were a number of states. This was, the Allahabad High Court ruled differently than the Patna High Court. All this was brewing and it was about to go up to the Supreme Court. And at that time, the first general election was also going to be announced. It was still the provisional parliament, which was the Constituent Assembly, which was, governing before the general election could happen. And they decided that they're going to amend the constitution. Now, the First Amendment, as you know, famously amended many, many things, huge restrictions on free speech and so on and so forth. But one of the really important things it did was it expanded what they meant by a state and the way they wanted to conduct land reforms through Article 31A. And second, through 31B, they introduced a new constitutional provision called the Ninth Schedule. Right? For those of you who are unfamiliar with the Ninth Schedule, it's a really bizarre thing which you don't find pretty much in any other constitution in the world. It says the following, okay? Any law that is added to the Ninth Schedule is completely protected or immunized from judicial review, even if it violates the fundamental rights, part 3 of the Constitution. Now, this is something quite extraordinary. Like, why would framers write a constitution and right off the bat create this kind of backdoor, right? Or create this kind of exception to the most important part of the Constitution? And the reason is they needed to end zamindari, right? It sounds like a very reasonable thing to do. The Constitution prevented implementing land reforms and ending zamindari without giving compensation, right? Giving compensation would have defeated the purpose. So either we give up the Constitution or we give up, zamindari abolition. And in this case, they found like this kind of middle path and they said, we're going to do this, right? And they were aware of this. They were aware of the magnitude of what they were doing. It was quite a bizarre move to create a schedule like the Ninth Schedule. And Nehru says during the debates, it's not with any great satisfaction or pleasure that we've produced this long schedule. We don't wish to add to it. It consists of a particular type of legislation, in this case, 13 land reform statutes, at the state level. And generally speaking, no other type should come in. Now, those of you, who have like even the tiny pocketbook version of the Constitution, if you open it today, there are 282 statutes in the Ninth Schedule, right? So it just kept expanding. Now, when Hayek was talking about the road to serfdom, the idea that he was also trying to persuade people of was very similar, right? That there is this problem of formal equal protection under the law, which is in conflict when the government is deliberately trying to make changes in substantive equality, right? So if we are deliberately trying to change the lot of farmers vis-a-vis their zamindars, right, we must treat them differently, right? Because then we must treat really large landowners differently from smaller landowners. And when we do that, we run into a problem. Suddenly, you cannot uphold your constitutional principles the same way, right? So just this is an observation. It is not about zamindari in particular, or price controls in particular, or some other plan in particular. You pick your favorite socialist instrument, demonetization or something like that, right? The idea is more general than that, that there is this tension between these two big principles, right? Now, in the Nehru years, you have, as I mentioned, the First Amendment is land redistribution. Then the second 5-year plan was going, it was mostly an industrial plan. But even before that, to set up a planning system, they needed to implement a lot of price controls, right? And this was done. India already inherited a number of price controls during the war years from the British colonial government. Some of those price controls persisted, but there were also some new price controls that were put in place, some new quantity controls that were put in place. The Essential Commodities Act was strengthened, right? A great book to read on this, by the way, is Rohit Day's People's Constitution, because it talks about how these kinds of infringements on people's ability to do business, on people's ability to, have their own trade and occupation, led to the creation of this huge administrative state that ordinary people were challenging. Anyway, so coming back to, the price controls, it ran into another big problem. Now, to have socialist planning, you need a certain degree of centralization, right? Price and quantity controls need to be consistent. Otherwise, there's going to be this problem between the different states. But when you're trying to overwhelm the system with this kind of, price and quantity control system, industrial planning system, one problem you run afoul with is the 7th schedule. Right? The 7th schedule, as you know, has 3 lists: the union list, the state list, and the concurrent list. And there are certain aspects which are left only to the states to legislate. Price controls typically get in the way of that, because different states will then have their own policies on whether or not they wish to have price controls and so on and so forth. And then it gets in the way of this kind of centralized economic plan that the Planning Commission was trying to implement. So what happened? Third Amendment, right? Then you come back, right? Again, you have zamindari, you have urban land ceiling propositions, the 4th Amendment, right? Centralization of industry, the 7th Amendment. The 17th Amendment was actually a whole number of things. It wasn't just zamindari, or it wasn't just price controls. It was a number of things going on in this particular instance. I believe 44 statutes were added to the 9th schedule. The 17th Amendment was in some sense the last big act of governance by Nehru. It was introduced in its present form, I think, the day before he died, and in that sense, it was sort of his everything he had been trying to achieve that had been thwarted by the judiciary. So in the few years before his death, was sort of ended up in the 17th Amendment in one sense. So if you open each of these, for the sake of time, I'm not going to go into each and every one of these amendments, but you just, look at the amending statute and you see what's going on, and you see that they are trying to directly give validity to a statute from the past, right? So you see this happening over and over again. The Planning Commission creates these plans. You have legislation to give effect to the plan. The legislation is challenged, as was the case of, in detail, I told you about the Bihar legislation. The judiciary holds it unconstitutional. The parliament has a choice between whether to overturn the judiciary in this instance, or whether to give up that particular socialist agenda. Every single time, pretty much, they overturn the judiciary. Now, if you come to by the way, none of this was done surreptitiously, right? All this is done in plain sight. It is done through proper democratic procedure. It's all above board. These are not sealed envelopes in the Supreme Court and so on and so forth. You look at the amendment, anytime you open one of the amendment acts, there is the first top of the act will always be the statement of objects and reasons. In every single instance, it tells you very clearly why Parliament is doing what it's doing. Right? In the First Amendment, of course, there were a whole number of things that were amended, but in the case of zamindari, very clearly says there is a lot of dilatory litigation which has held up the zamindari agenda, right? And we are passing this amendment to give validity to these, land redistribution, land reform, zamindari abolition legislation, right? It's very strange phrasing to say we're going to amend the constitution to give something constitutional validity, but that's what they were doing, and they were doing it completely above board. They were doing it because they believed in socialism. Now we come to the Indira Gandhi years, right? There's this huge mythology that, India's constitution was doing great, and, Nehru was this great constitutionalist. Then comes Indira Gandhi and emergency happens and all hell breaks loose, right? But you see that the trend that was started by Nehru continues with Indira Gandhi even pre-emergency, right? Now, one of the things that happened because of so many constitutional amendments, both during Nehru's term and then once Indira Gandhi was prime minister, was over and over again, the power to amend the constitution would come up, right? And this is there right from the beginning. So again, for those of you who've had that constitutional law sequence, one of the first cases we read when it comes to constitutional amendments is the Sankari Prasad case, right? Sankari Prasad case is directly challenging the First Amendment, right? The question is, does Parliament have the authority or the power to amend the constitution as written in Article 368? This question keeps coming up over and over again, right? So it comes up in Sankari Prasad, it comes up in Sajjan Singh. Now, finally, it comes up in Golaknath, right? And for those of you unfamiliar with the case, this is again something that was born out of land redistribution. Golaknath, they were the Bengali farming family who were living in Punjab. The Punjab statute, of course, tries to take land without giving compensation, amongst a whole number of other things that the statute does. They challenge the statute. It keeps going up in challenge. But eventually the question that emerges is, did Parliament have the power to amend the constitution and actually pass these statutes and put them in the ninth schedule? That's really the core of it, right? And in Golaknath, the Supreme Court by then, remember by now you've had about 17 years of, the constitutionals working and functioning. You've had more than 20 amendments. And at this point, I think the judiciary sort of had it, right? They're like, look, there are too many constitutional amendments and all of these seem to keep infringing on these fundamental rights. And they say that Parliament does not have the authority to amend fundamental rights in the constitution, right? So this is the Golaknath. So again, please remember, I'm giving you the Cliff Notes version. This is, of course, hundreds of pages in this judgment, and there's a lot of, nuance and specifics on what's going on. But the crux of it is they take that authority away from Parliament. So what does Parliament do? Mrs. Gandhi does the same thing that her predecessors did, right? You amend the constitution anytime you run afoul with the judiciary. In this case, it was the 24th Amendment. The 24th Amendment is really funny to describe because they amended the constitution in order to get the power to amend the constitution. And there is no easy way of saying that. I know it sounds really funny. I don't intend it to be. But basically, there's, extra conditions and clarifications written into Article 368 to regain the power to amend the constitution. Once this power is regained, Mrs. Gandhi goes about, her business. As you know, she was a socialist of a slightly different grain than Nehru. She believed in taking India to the commanding heights. The commanding heights is this phrase that is used to describe socialist, planning. And she wanted to go very much the Soviet way. Nehru wanted to implement a kind of Fabian socialism, which is very gradualist. She wanted instead to overnight acquire all the means of production, take it away from private individuals and use it for the state development plan, right? So the first is bank nationalization. Banks were nationalized overnight. This was done by ordinance. If it hadn't been done by ordinance, there would have been a really, really big problem in terms of all the capital flight, if banks know what's going to happen. So, you had bank nationalization by ordinance. R.C. Cooper, of course, challenged this. There were various parts to the challenge, but the crux of it was, just compensation, taking of property without just compensation, because the payment plan of compensation were, bonds that would mature in 10 years or something like that. It was absolute pittance. Basically, the banks were just taken over overnight, right? So this is the 25th Amendment. The 26th Amendment actually is not to do with the fundamental rights. It has to do with transfer of power, which is Sardar Patel and V.P. Menon had struck a whole number of deals with various monarchs. And in exchange for ceding their property and the right to collect taxes, these monarchs were given a purse, right, the privy purse. And this was abolished because as part of her campaign, she wanted to end the aristocracy and bring about a more equitable distribution of wealth. And this was directly, in support of that. Once again, she passed a number of land sealing laws. The previous land reform laws, as you know, were not successful, right? There was still, according to the government, very high concentration of land. Now, of course, we have the opposite problem. 3 generations pass, and what you realize is land holdings start becoming smaller and smaller. So now we have the opposite problem of India having some of the most fragmented, low productivity, small holdings of land. But at that time, they thought the land holding size was still too big, and they imposed all these ceilings. Once again, it was challenged in the judiciary. It went into the 29th Amendment. Land redistribution, once again, 34th Amendment. The 34th Amendment is also the challenge, 29th, 34th. These things eventually come up and brew up into what is the Keswanand Bharti case, right? Once again, the question of whether Parliament can amend the Constitution. And we all know the basic structure doctrine. It's slightly different from Golaknath in the sense that it says, yes, the Parliament does have the power to amend the Constitution, but it's not unconditional. And it tries to impose these ex post conditions. We'll know it when we see that you're in violation of the basic structure. So, people who wrote the Constitution figured out that there is this problem. Right. In a case, when we're talking about the 4th Amendment, this came to bear when private transportation companies, private bus services were no longer allowed to operate because the state wanted to cancel those licenses and operate it themselves. Right. This, as you know, is a direct contravention with, at that time, Article 19(1)(f) and G, which is private property and right to profession, trade and business. And this came, eventually to bear on the 4th Amendment, among other things. And you can just imagine what it must have taken Dr. Ambedkar to say this about a constitution in the framing of which he had been so deeply involved, right? He says, burn the constitution. That is, of course, the polemical, but there is, when you read this particular parliamentary debate, there is some deep anguish over the fact that the document that was crafted to create a particular kind of society is now being taken over and amended over and over again for personal gain. And remember, this is in 1954. This is well before Mrs. Gandhi does anything, right? The emergency sees the worst of it, right? Mrs. Gandhi says we should be vigilant that the march to progress is not hampered in the name of the Constitution. Even Mrs. Gandhi is aware that progress in socialist terms requires the Constitution to take a step back, right? During the emergency, she does more of the same, right? There are price and quantity controls in the 39th Amendment. There are currency controls, monopoly restrictions. This is your FEMA. This is, FERA at that time, MRTP, things like that. I want to talk a little bit about the emergency and the 9th schedule. So as many of you know, the emergency was eventually one of the unintended consequences of Mrs. Gandhi trying to hold on to her power. And the reason her power was challenged was because she had used a few government vehicles during her election. And Raj Narayan, who was the candidate who was standing, against her in that election, had evidence that she had used government resources for the election, which is not allowed according to the code of conduct put out by the Election Commission, and therefore her election was invalidated, right? So this goes up to the Allahabad High Court. The Allahabad High Court, upholds it and says, Mrs. Gandhi has, I think, 2 weeks or something like that to appeal this and, challenge this, but if the challenge doesn't succeed, she must resign her Lok Sabha seat and therefore resign as Prime Minister. And in this period is when emergency is announced, right? It's a very, very clear way of trying to hold on to her power. Now, before all these price controls, quantity controls, any of that happens, one of the first things that Mrs. Gandhi does during the emergency is that she actually amends the Representation of People's Act and the Election Act. Right? That the Prime Minister's election cannot be challenged in a court of law and things like that. And the Prime Minister cannot be ousted. There's a whole bunch of really bizarre, dictatorial sort of sounding. You suddenly think you're in some tin pot republic when you look at those statutes and the amendments. And those amendments went directly into the 9th schedule. Right? So you kind of start seeing Hayek's prophecy come true right? What starts as a device to escape some constitutional constraints because they were very well-intentioned framers trying to implement zamindari, now those same provisions are being used to hold on to power, right? The worst of it is the 42nd Amendment, separation of powers completely starts breaking down. The power of the executive rises. Judicial review is completely circumscribed in the 42nd Amendment. There's an attack on democratic elections. Federalism is circumscribed because, once again, she wants to hold on to power at the union level. And of course, fundamental rights and writs in particular take a beating. Right. Most of the excesses of the 42nd Amendment we don't live through, thankfully, because they were undone in the 43rd Amendment. Because right after the 42nd Amendment, she announces elections and she loses. Raj Narayan incidentally wins that seat. But, right, you still get more of the same because the Janata Party comes to power, right? This is Morarji Desai's government. And Morarji Desai undoes most of the really horrific excesses, as I mentioned in the 43rd Amendment and partly in the 44th Amendment. But they delete the right to private property, right? That is one of the aspects which is consistent between Indira Gandhi and Morarji Desai, who otherwise seem like such different people, right? Indira Gandhi is a dictator who imposed the emergency. Morarji Desai is this benign Gandhian socialist, the most incorruptible, principled man led by, Jayaprakash Narayan and so on. But what you see is the same problem. It's not about the individuals. It's not about Indira Gandhi bad, Nehru good, Morarji Desai good. It's not that. The problem is there's this fundamental tension between implementing socialist policy and at the same time holding on to certain provisions of the constitution, in this case, the right to property, right? So post-emergency, the right to private property is deleted. Right. I sort of stopped my analysis in 1980 because, the peak of socialism starts diluting after that. But you do get some remnants of socialist policy, such as urban land sealing and things like that, pop up again in later amendments. But that is because of policy that was instituted during socialism to implement socialism. Right. And in this particular instance, Morarji Desai once again says it has been the occasion of more than one amendment to the Constitution. So just think about this for a minute. The way socialists are thinking about the Constitution, they're not thinking about the Constitution in terms of constraints, right? They think of the Constitution as this kind of guiding document, right? So if the guiding document doesn't let us implement socialism, we'll just change the guiding document, right? And it doesn't look good to keep changing things. So, in this instance, maybe we should just do away with the right to property. Right. Once again, we circle back to Hayek. In this case, it says clash between planning and democracy arises simply from the fact that the latter is an obstacle to the suppression of freedom, which the direction of economic activity requires. So all the kind of centralization of power, control over means of production, right? A requirement to treat different groups of people differently, right? Enormous amount of discretion in the hands of the government, as we see in the case of bank nationalization, to just, overnight take over 50% of the banks, of the capital and deposits by ordinance. All of these things are directly in clash with the kind of values one requires for a constitutional democracy, right? Now, I'll just end in a couple of minutes. Now, why does this matter? This matters for two reasons, right? One, it serves as a cautionary tale in the institutional design, right? It highlights the importance of why we need to craft institutions which are congruent, right? Which can work with each other. So just because we throw in directive principles and start implementing more and more of the socialist policy doesn't mean it's possible just because it's in the same document. Right? The principles need to function with one another. And in this case, a lot of the socialist agenda just runs afoul with the other principles that the framers wanted in the Constitution. And the second, I think this matters a lot going forward, right? As we saw in the case of Mrs. Gandhi, completely using the ninth schedule for her own personal needs when she lost the election, or rather her election was nullified, you see this over and over again as we move from a socialist economy to a capitalist economy or a free market economy. The problem is when there is this kind of discretion and all the fundamental rights and the institutions have been chipped away through 103 amendments. Now you are in a world where there is lot of political power centralized in the executive and the union parliament. And at the same time, it is very easy to capture that power by a few really wealthy people or a few large businesses and so on and so forth, right? And without the appropriate checks and balances, we are not going to be able to escape this cronyism. We're in fact going to go straight from cronyism, crony socialism to crony capitalism. So I'll just stop here.